Back to the motions with the two officers. Now they calling Erick Hernandez, and as I can tell you guys this, I point out all kind of technicalities in their faulty confessions. Roger Smith said that my phone was on the floor, and now Hernandez is going to testify and say that he found the phone in my pocket. I want you guys to really listen to how they really did me wrong, and it's so sad that all these people went to the extreme just to make sure that I get a conviction, a wrongful conviction on my record. Now he done made it extremely hard for me to find work so I can pay for this so-called sex offender polygraph that I have to take to clear my name. You know, I'm willing to take it. I mean, if you put it on me, then give me some type of resource to take it to prove y'all wrong again, Douglas Hanson, because I'm really not even mad. I'm sad. I'm hurt in the inside. And when people hurt of pain, you see on the news they start to do stuff to lash out at individuals or at innocent people, and that's not fair. What needs to be done is someone sit down with me and go over this case thoroughly, and that's all I can say about it, because these officers lied. 1 minute I'm in room 319 according to Roger Smith. He couldn't even keep his story straight because he testified to room 319 when me and my wife was in a double bed room 419. There were two beds. The closet which I was supposedly found hiding in was directly across from the bathroom, and furthermore, me and my wife was in there together. I panicked out of fear because I didn't know what was going on. I was under that pill. I had taken that pill, and I was crying and complaining about what was going on with me. But they didn't want to listen to that. They handcuffed me, dragged me out at gunpoint, took my phone off the floor, brung me up, tried to split me and my wife up, sat me in the bathroom, and Hernandez said to me, "You want to be a drug dealer, huh?" Are indications of going through my phone. He picks it up already off the phone, so off the floor. And it's so sad, because they had no authority to arrest me. Fruit of the Poisonous Tree says you did illegal search and seizure on that phone, Hernandez, because I never gave you permission to go through it. I never read you off 0550 because my phone wasn't never passcode protected. I don't know where that 0550 came from. My codes, I don't have any codes, because my phone is open for my kids to play the little games that was on it. Why would I put a code on it to lock my kids out? Furthermore, you guys lied more, saying that I wasn't sick. I threw up plenty of times. Y'all all rushed the bathroom. Y'all knew I was sweating. I had shivers. I needed blankets. Yeah, y'all thought y'all sent me to jail, but the jail wouldn't accept me. It wasn't because I was tased or none of that stuff that you making up. It was because I threw up in that car, and when they let me out at the precinct, I kept throwing up. I can remember I needed two IVs directly in both of my arms because it was so vague to me that I couldn't see, because this pill was tearing me up in such a way that y'all just don't want to see the truth. Why? Because y'all police officers? That don't even make sense to me. How that y'all can sit here and come and raise your right hand under oath and tell these horrific lies. And not only that, don't this ring a bell how me You and your officers was all sitting in the hallway and Roger Smith was trying to direct you in your testimony, Officer Hernandez. You know for sure that you didn't verbally read me my Miranda rights. You took me right out of that closet, got a gunpoint, and you went directly into questioning me. And that's as simple as that. Cause why would an officer read somebody they Miranda rights twice and still forget to have that person sign the card? But you uncuffed me to sign for room in my car. No, I said none of this stuff belonged to me. This room is in my wife's name. Those is her laptops and her 2 phones that y'all got. That stuff don't belong to me. The only thing that belonged to me is my car. I'll give you permission to go to my car because there ain't nothing in here that you gonna find that's illegal. And I signed it. I never gave you permission to go through my phone because it wasn't on your mind at the time. You were trying to entrap me into saying things that wasn't true about myself. That's why I said, look, I need help. I know what you're trying to do. You're trying to make me out to be somebody. I don't want to talk to you guys no more. But you insisted to talk. You insisted. You went against my constitutional rights when I said, look, I know what you're trying to do. You're trying to make it out for me to be somebody I'm not. It's funny that I can recite all this stuff without looking through a police report, because when you got truth in your mind, can't nothing else hold you back. I don't need a paper trail to show the slanderous things you guys done to me. What really needs to go on is that Erick Hernandez, you need to be fired immediately because you're lying to cover for another cop. And that cop lied and lied and lied. He even lied under oath when he heard Judge Tripp say, "What is your full name?" He said, "Roger Smith." What is that? That's lying. Your name is Roger Gerald Smith. And I can assure you, you people pushed me to a limit, got my feelings in it, got me open. While I'm reading all these information, all I do is lose sleep. All I do is have nightmares. All I do is shiver. I'm on 400 milligrams worth of Seroquel because I gotta slow my mind down because of what you people done to me. You guys made me into this sex offender, but I get to come home and lay with my wife. Why? Is it because Rule 505, husband-wife privilege, that district attorney forced my wife into being a victim to get a case prosecuted against me? Dang, I wonder what legislator is doing this. So you mean to tell me that you guys are bringing in other government officials higher ranked than you because you were chairman of domestic violence in your little public community, Douglas Christopher Hanson? I think you really need to look deeper into why you became a lawyer in the first place. Didn't that what you told my wife? That she didn't know what she was talking about and that she wasn't a lawyer, but we study law just like y'all. Just the same format, everything. ORS Rule 505, 1 through subsection 4. None of it never applied. I never was caught committing bigamy on my wife. So therefore that rule was exceeded out, and you still chose to take upon yourself. So now Douglas Christopher Hanson think he got a sealed case because he called 2 officers to the stand on me. And now I'm going to let you guys get 46 minutes and 5 seconds of pure slander from an officer who don't want to tell the truth, and he's getting called up. He's saying that now I'm correctly in room 419 when Roger Smith's whole testimony was in room 319. Red flag, do you think? I'm talking to my lawyer. saying if they gonna bring evidence, make sure they bring it all. Why y'all not talking about the $90 that they took from me? She said, you don't want more evidence on you. I'm like, but if they gonna tell the truth, tell the truth. In a police report, it says $12.90. And I said, we'll deal with it in motions. She said, we already at that point.
It worked out just fine. My staff had some questions.
Yeah, she asked for the recess for me to put up my evidence so they could crucify me in the court of law. This is so much hate.
To affirm the information that you're about to give in this court cause shall be the truth. Have a seat, please. Once you're seated, state your entire name and spell your entire name.
My name is Erick Hernandez, and Erick Hernandez is spelled ERICKHERNANDEZ.
Okay, counsel. Thank you, Your Honor. Mr. Hernandez, what do you do for a living?
I am a police officer with the City of Salem, currently assigned to the Street Crimes Unit as a detective.
And how long have you been in law enforcement?
I've been with the City of Salem as a police officer for just over 7 years.
And can you briefly describe your training and experience in law enforcement?
Sure. Initially began my training as a police officer with the Basic Police Academy through the Department of Public Safety Standards training with approximately 740 hours to complete that basic academy. After that, each officer goes through what's called field training, which lasts anywhere from 5 to 6 months, depending on the officer and how they progress through that training, which allows me to come in contact with the public. Actually allows me to have hands-on training in the, hands-on experience with different types of police investigations, everything from the basic standard traffic stop to assaults, sex assaults, drug investigations, thefts, the gambit basically of police work. Additionally, I've attended approximately 80 hours worth of drug-specific training with the Oregon Narcotics, ONEA, which is the Oregon Narcotics Enforcement Association. Thank you. And ONEA basically provides narcotic-specific training, which is very specific to my role as a street crimes detective. I've also gone through the DEA Basic Academy, which has given me additional drug training through the DEA, which is approximately another 80 hours. Aside from that, a lot of my experience is basically hands-on through police work. So.
All right. Can you tell us then, did you assist in the investigation that took place on May 16th of 2014 involving Matthew Mayfield Johnson Jr.?
I did.
Tell us about your role, please.
My role was basically to assist detectives, primary detective working that case. My involvement really didn't begin until the actual execution of the operation, where Detective Smith engaged in or set up basically what we consider a sting, in which he made contact with a Jessica Johnson, basically in answer to a Backpage ad, an internet website advertisement, and so that initial contact, I should say, basically occurred at the Shiloh Inn Suites located at 3.
They stutter a whole lot.
Right. And so, tell us, Detective, then, were you one of the officers that had entered that hotel room that day?
I was.
And
yes,
tell us
he
about
was.
your contact with the defendant.
So, initially, Detective Smith approached the front door of the room, and after knocking, the door was answered by Miss Johnson. And if I remember correctly, she was wearing a pink.
If he remembered correctly, he know.
Underwear. That was about it. There wasn't really much that she was wearing at that point.
So why frisk her down in front of her husband? Why touch and grope my wife?
Behind him, and we made entry into the room. After Detective Smith contacted Miss Johnson,
they the ones that
Detective D
committed
began
the
to check
crime.
the remaining rooms that were in there, which was basically a bathroom and then a small closet.
The closet wasn't
Detective
small
D was
at all.
looking in the closet, he immediately yelled, "Show me your hands, show me your hands." And that was obviously a clear indication to me that there was somebody else in the room. Detective Dee drew his gun, and as did I. And
right here in my
face. Our point of fire to the closet, and Detective Dee ended up giving commands for
fear.
Mr. Johnson to step out of the closet.
What would a black man do
after that
when the police is already killing all of us? What?
They're on the floor in the middle.
What?
And do you see the defendant here today?
I do.
Of course they see him. I'm not the perpetrator.
Yes,
they are.
Can you tell us, Detective, you said you drew your weapon, so you had your weapon on you.
I did.
Were you in plain clothes or in uniform?
At that point, I was in plain clothes, but I was wearing a ballistic vest underneath, and I did have my badge. Generally, when we do these types of investigations, we approach the location in plain clothes with nothing visible, but as soon as we get to the point where we are actually going to identify ourselves as police, we'll make our badge visible either by a neck chain or just on our belt.
So was it visible on this particular occasion when you had contact with the defendant?
I believe it was.
Right. And in telling the defendant, getting him down at gunpoint and handcuffing him, you said that you told him he was under arrest.
Correct.
And you signified you were a police officer?
I did.
And what did you do next with the defendant?
At that point, I separated him from Miss Johnson. I actually escorted him into the bathroom, which was just to the right of the entry door. So a small bathroom just in the room.
How long were you guys there, or what did you do?
At that point, I advised him of his Miranda rights first thing, and after doing that, I'd say I probably spent a minimum half an hour with him in the bathroom.
You read me my Miranda rights.
I advised him of his Miranda rights.
You're lying.
And I basically began an interview with him.
Did he?
Out of fear, you put me in handcuffs.
He stated he understood his Miranda rights.
You wasn't. Your mind wasn't on Miranda rights, Hernandez. Because out of fear, you put me being in the closet. You was focused on what kind of criminal I was, right?
Basically, one of the first things we do when we come into contact with someone, and since he was in handcuffs and he was hiding in a closet,
I wasn't hiding. I put my hands out when they knocked on the door and arrested my wife. I was already revealed.
Officer safety concern, and he was going to be cooperative. And since the Miranda begins so early in the contact, he did not sign the Miranda card itself. So.
No, I did not.
He wasn't able to with his hands.
No, it's because I wasn't aware of a Miranda.
I'm going to hand you what's been marked as State's Exhibit number 1. And can you identify that for us, please? I do have some scissors here, and I'll ask you to actually open that up, and we can pull out the contents as well.
Sure.
This man is really ill, man. He's sick for trying to cover.
This is the Miranda card here that I read to Mr.
Smith.
Johnson, and indicating the date.
Watch how he testified to his own lies.
And there is no signature on that second line, but it does indicate handcuffed.
And is that typical that you
He wrote handcuffed because he didn't have my signature. That's lies. They don't got no place doing that
he did
to me.
Acknowledge his rights then.
He did.
No, I didn't. I was too sick, throwing up, ill.
In that bathroom.
Correct.
And after reading Miranda rights, you had questioned him and talked to him about a lot of the investigation, correct?
I did.
At any time during that conversation, did the defendant complain of pain or discomfort or anything like that?
Yes.
No, actually, contrary to that, I remember asking him a series of questions, and I remember him actually...
All this in 30 minutes.
Distinctly remember him actually laughing at some of my questions as if...
Why would I laugh?
...comical into how I was asking them. The only thing I do remember him asking, or basically complaining about, was thirst. He said he was thirsty at one point, which I provided him Gatorade.
Which is a symptom of the metformin pill that I was taking. That's one of the symptoms that I was needing water or something.
Discomfort and pain specifically, no. At one point during the interview, and it was very spontaneous and random, and I remember having to act quickly so that I could allow him to do so. But he was seated on the toilet in the bathroom, and just at one point, kind of randomly, he said, "I think I'm going to throw up." And so
I never said I think I'm going to throw up. I just threw up because I couldn't hold it no more. I just threw up and they all rushed the bathroom. That's the truth.
Did he ever tell you that he was on any kind of medication? that was.
Yes, I did, because it all was on the counter. Don't you remember? I had a medicine bag, a black medicine bag. It had all my medicine
he
in
was
it.
in, not talking about medicine particularly, but just saying, I'm really not feeling right. I'm not understanding you, or I really can't communicate very well with you.
After he vomited, he told me that he had, and I'm sorry, I don't remember what the condition was, but after he vomited, he told me that he had a specific condition and that this was common for him to vomit and not to be able to keep food down.
I don't have no condition. I don't randomly throw up. I was taking a metformin pill that had me throwing up, and I had no control of it because I thought that my doctor said I was a diabetic. And it was wrong.
So let's go through then, after you had read.
Look at this slander. This has hurt my heart every time I listen to it. But I gotta be strong enough for God to do God's work.
I did.
Can you tell us about that, please?
Initially, I asked him what he and Miss Johnson were doing there at the location, and he indicated to me that they were on their honeymoon.
Now, why would I say I'm on my honeymoon when I know exactly the difference between a honeymoon and a rendezvous?
Being there.
That's like saying I'm stupid. I don't know when I married my wife.
Initially told me that he didn't really know what I meant by what his role was. I asked him, after, like you said, basically explaining the investigation and why we were there, I asked him to tell me how he might be involved in Miss Johnson's prostitution activity. He kind of laughed at my questioning. And I remember specifically saying, he said, I see what you're doing. You're trying to get me to say I'm doing something.
And I want to see a lawyer immediately.
Basically told him
he left that part out.
Be honest about what was going on at that point.
He still forced the interview.
Exactly he was hiding in the closet. His response to me at that point was, quote, all right, I'm going to be straight with you. I hoe too. We hoe too.
So why do I got promoting prostitution if I told him that I hoe with her? It doesn't make sense. They lying. But I got promoting prostitution.
He replied, and I quote, I mean, I suck and I fuck with her.
See how he reading off his notes?
If he was
stuttering still,
engaged in sexual activity with Miss Johnson in exchange for money or other types of payments, and he said, yeah.
All right. Did you talk to him about, other than just the two of them in this agreement, were there others involved, and what his role was?
Yes, so basically the way he explained how some of these arrangements would work, he said that if somebody wanted to engage in sexual activity.
Why they keep saying I guess?
He would be
These
a part
people
of that
is
deal, but they would
weird.
not know that he was a part of that deal until they actually reached the location. And I asked him if he meant to tell me that if someone agreed upon those sexual services, that he just included him in the service.
This is him testifying on the fact that I'm a supposed prostitute. Nothing to do with promoting it. You get what I'm saying? It's like they don't know what
Miss Johnson never actually
they talking about, but they charged me with promoting prostitution and delivery of an oxycodone, and I never did either one.
And he said when they show up is when he explains. And I asked him how that usually goes over with the person that shows up expecting to meet with a young lady and then realizing that he was there as well. He said, we are all consenting adults and it's just casual fun. That was his explanation and reasoning behind that. I asked him if anyone actually agreed to this once arriving at the location and knowing that Mr. Johnson was going to include himself in the activities. He said yes, and if they don't feel like they are going to include themselves, that they would just sometimes watch. That would be part of the agreement at that point.
Boo! That's a lie. That's a lie. I told him that me and my wife had contracts.
As far as the agreements, if for some reason he said that they didn't want
doing
to
webcam.
Include themselves, that they would just...
I told him that me and my wife does webcam. That's exactly what I told him. And you can find that information located on Kerry Weiland's notes.
Notice that there was a phone that the defendant had at this time?
Watch this. Watch this. This is where they stories mix up at.
If I remember correctly, he had it in a pocket.
Oh, but Roger
and
Smith
did
said
you talk to him
he
about
picked
his
it
phone
up
when
off
you
the
could look at
floor.
it?
I did.
Tell us
He
about
said
that.
it was in
So
my
I asked him
pocket.
if I could look through his cell phone, and his response was, "Go ahead, you can look through whatever you want." So at that point, I read Mr. Johnson, the department issued.
Again? Come
consent
on, you
search
gonna read
card,
it to me
which
again and I
actually
not
had
sign it?
allowing us or asking for his consent to search.
This is
And if I may,
illegal. This is
clarify
fruit
to you, this is
of the
actually
poisonous
second time
tree.
that I had
This
read
is a
specifically that
federal
part to him,
law that they are breaking
prior to
right here and right now.
initiating my entire interview with
Watch
him.
how he testified
Other
to
detectives
how
were
he
going-
just
preparing to
quickly
search the room,
forget
and since the room
that
was
he
shared
need my
between him and
signature.
Miss Johnson,
And this
I
room
read
was
it to
never
him the
shared
first time
between me
while
and
he
my
was still
wife.
handcuffed.
It
Read
was
it
in
the
my
first time,
wife's
and he
name.
agreed to allow us to search the room and the possessions that were there. So this was actually the second time that I had read the consent search card to him. So he agreed to the consent search. I actually, at this point, removed him from handcuffs.
Wow, what do you know?
And why now at this juncture? would
Yeah,
you
why
remove
now?
handcuffs
Why?
For the phone,
And look at
not
the poor
initially
lame
after the first
excuse
Miranda
they
rights
give.
were read.
I had spent significant time with him talking about
Seeing how
what was going
sick
on,
I was
talking
and
about
how
the
hard I was
investigation. I could
rocking
tell
and
that
how
he was
fast
being
my
what I
heart
would
was
consider
beating.
cooperative. He
That's
wasn't
what
being
you was
violent. He wasn't
witnessing.
being offensive.
Tell the
He
truth,
was
Roger
talking to me
Smith.
in
I mean,
a calm manner.
Hernandez.
So at that point, I
Tell the
considered him
truth.
not necessarily to be a threat, so I felt safe at that point for my safety.
Both of
to
y'all
remove him so
lied.
that to allow him to sign the consent
Nothing
search.
but
So that at that juncture,
liars,
your office had safety
liars,
concerns were
and
removed.
liars.
All right. You did have him sign that as
I
well?
did.
Is that part of Exhibit 1 that I handed you?
Yes, it is.
And can you describe for us then on that card, did he sign that and did you sign that?
I did. So he signed it. Well, you can see on the first line where his signature would be. The initial portion of it says yes.
How did
which I
this
wrote,
judge
and that would
let
have been for
them
the
get
first time
away
that I read
with
the
so
consent
much
search
wrong?
card. And then right next to it,
Was
is
she
his
really
signature.
in cahoots with the whole
And then
plan and plot?
My name is listed at the bottom.
Maybe it was because they knew I could sue
Your
them
Honor, this
for
time I would offer State's Exhibit 1.
what they done to me. They made me do 22 days with no PO.
Yes, please. Yeah, let me.
22 days with no PO, no sanction. I did. Sick. I was stopped from being seen from my
I'm
doctors
sorry,
to
there's
see
a
what's
second one here
wrong
for
with
Miss
me.
Johnson.
They used my wife evidence that they charged her with against me in my criminal case. That's crazy. It just says room and car. Like I said, they only asked me to search my car, and I don't know how they wrote room on there because the room was never shared with me and my wife.
So yes,
My wife
thank you.
got that room on her
So this
own.
particular one that the defendant had signed, it says room and car here.
Correct. So that
Why
would have
was
been
in
for
this
the
case
first
dismissed
reading
then?
Of the consent to search.
Why
I
did?
read
How did
yes.
that information
The second
get
portion,
past
yes.
a judge that studied her whole life?
But I did
Listen
fail
to
write
this
something
mess. This mess
beside
is
his
just
name or
all
in any
over the
open area,
place.
I guess, of that card.
This top portion says
They can't
all
take it
property
back
within the
now.
premises that you're allowed to search.
I
That's
need
what's-
justice.
That's correct.
I need help from the public.
Right, the second time, yes. And that's when he signed.
So the
You
first
gotta
time
listen
kind
to
of
these
went
deep,
in handcuffs,
deep,
you just
deep,
wrote in the
deep
car where he
thoughts of
said, yes,
mine.
you can search all this.
That's
Somebody out
And then
there
when he
gonna
finally said
hear.
yes, quote, yes, and he
Listen
signed
to
his name,
this.
That was for his cell phone.
Well, I wrote yes after the initial reading for the room and card because he was unable to sign. And then during the second portion, when I read it the second time, that's when I removed him from handcuffs, and he was able to write or to sign the card himself. But I didn't write specifically cell phone or anything on any of that free space that's might
Just
be
all
remaining.
inclusive.
Correct. Yes.
Okay.
Why?
So, Detective, so that
Yes.
I'm sure I'm clear, you use the same card twice?
He used the
Yes.
same card twice for
Yes,
two
that's
different
correct.
things.
No objection to State's Exhibit 1?
Cause she didn't want to help me, so she let it ride. She could have ate that up and man, I'm telling you, a real lawyer would have ate that moment up right there. That's unethical to do. You gave me an interview for approximately 30 minutes and you still chose to break the law. You broke the fruit of the poisonous
Thank you,
tree.
Your Honor. So, Detective Johnson, excuse
Look,
me,
he called me
Hernandez,
Detective
did you ask
Johnson.
Mr. Johnson then
You're right.
if he could provide you the passcode to actually access his phone?
Yes, I did.
This
I
is
noticed
a lie.
immediately when I
My
began
phone
on
was
the
in
phone that it was
passcode
password
protected.
So I asked him
This
if
is
he
lies.
would provide me that passcode so that I could actually review.
My
the
mama
contents
can
of the
get
cell
into my phone.
And he did. He verbally provided me the code 0550.
I don't even know what
Punch that
that.
in?
I don't know what
Did it
that
access
goes
his
to.
phone?
Yes, it did.
And again, you only knew that from the defendant telling you what it was, correct?
That's correct.
And
So were you able to then look at text messages on that phone?
I was. I reviewed several messages. One contact in particular reviewed messages from a contact listed as Moneymaker. After looking through the contact listing, I saw an associated photo with that contact, as many cell phones will allow you to do now, and I recognized the photo of the person to be Miss Johnson.
The same Miss Johnson that Detective Smith had made these arrangements with.
Yes, that's correct.
All right.
During the
Smith
text
made
message
his
conversations that I
arrangements
reviewed
with.
between Mr. Johnson and Miss Johnson, Miss Johnson made reference, several references to having
at him stuttering.
quote, a lick. And in my experience and training experience based on human trafficking and prostitution type investigations, I know that term is common for referring to a John or a male subject engaging in soliciting prostitution. So somebody that the
now
person
this is
planning on
him
meeting with.
testifying to me being a
And,
pimp. But
on the
earlier he
defendant's cell
testified to
phone,
me being a prostitute.
Was he listed as quote P, the letter P?
Where's this information
I did
at?
read several text messages where he had actually referenced himself as P, just the letter P.
That could mean
again,
punk,
just kinda
pussy,
based on,
anything. But they
training
called it
experience,
pimp.
In these types of investigations,
This is
I know
wrong.
the letter
This
P
is
to be
real
short,
slander.
a way basically to commonly refer to someone's self as a pimp. And I specifically asked Mr. Johnson why he was referring to himself as P in his text messages.
What did he respond?
His reply was, all right, I'm going to be straight with you.
Again, I said that twice. I said that, all right, I'm going to be straight with you. See how
I lived my life.
it's all just
I asked him
written out
what
like,
exactly or how exactly he
No.
portrays himself. To
I don't
be a
even
pimp.
talk like that.
And he just said, like on Facebook and stuff. I just do it because that's what people expect.
Nobody expect that of me. Nobody.
In reviewing more of those text
Nobody, I
messages
repeat.
that were on the defendant's phone, did you come across any indications of drug activity?
I did. I came across another text message conversation where I found an outgoing text message where he told the recipient of that message that he had 50 oxy pills for sale for $200. And later, after talking to Detective Smith, I learned that there was actually a prescription bottle in the room that contained 50 oxy pills.
All right. Based upon that contact with the defendant, then, did you
He
arrest
called
him and
it
charge him with the
conduct.
prostitution, compelling in the delivery of the oxycodone?
He
Yes,
said compelling.
You know, this was all within,
Where's the children at?
County?
In the compelling.
And
You
we
see
understand
that?
from Detective Smith, this was also in within
Slander.
1,000 feet
Call
of
me a compeller.
elementary or vocational school in Marion.
That's correct.
Lastly, Detective Hernandez, when you arrested him and took him in, did you end up taking him to the hospital?
I specifically did not transport him anywhere. Because of our location and kind of how our team sets up these operations, we're generally not able to conduct transports, so a patrol officer will respond to the location and conduct our transports for us.
And is that because you're typically in plain clothes and unmarked vehicles?
Correct.
So you don't want him transported by an actual marked vehicle with an officer in uniform?
Right, correct.
All right. And again, anything unusual about the contact you had with the defendant where he wasn't understanding you or any of the questions or things you found?
No, at no point do I feel like he couldn't understand me or like he didn't. It was very clear that he understood what I was saying and I understood him perfectly well.
Thank you. Nothing further. 1 minute.
Wow. Straight slander.
Talks
She like,
faster than I type.
the judge asked to look at the consigned and consent
you.
cards. She should have
Good
threw the
afternoon,
case
Detective
out.
Hernandez. You have no idea where Mr. Johnson was, or if it was Mr. Johnson that sent the text messages from his phone, do you?
No, obviously I did not watch the.
Right.
actual
So
messages.
why,
Okay.
again, why am I charged this
And
way?
with regard, do you know that he was in fact transferred transported to the hospital on the way to the jail?
I was informed of this later.
Okay. But
They
you
knew
didn't do
because
the
I was
transport.
sick.
No, I did not.
Trust me.
That it's somewhat unusual for a person to be transported to the hospital before being taken to the jail, isn't it?
I think more so nowadays it's becoming much more usual because of, not because of the person's condition, but because of the jail policies.
Okay, but if there's any concern at all about a person's physical condition, they need to be checked at the hospital.
Correct, yeah. It
Okay.
could be depending on use of force, like specifically if we use a taser, that person needs
Which
to be checked
didn't
by a
happen.
medical professional. Not that it's
Sure.
life-threatening or that their physical condition is that they're unable to do anything or they may be just fine, but it's just because of that policy they are required to be evaluated first.
Okay.
So.
But in this case, when he was brought out of the closet, to use that turn of phrase, you wouldn't say it was
You hear the
excessive
laugh
force,
in the
would you?
background?
Oh no, definitely not.
And in fact, although guns were drawn, I guess this is
Poor
obvious
black
from
man
his
scared
testimony,
of
but
the
nobody
police.
shot at him,
That's
right?
correct.
Okay,
I
and
would've
nobody
hid
used their
too.
taser.
Correct.
Just like I did.
He did throw up when you were talking to him?
He did, yes.
Why would I just throw up for like 2 or 3 minutes?
Yeah, I specifically remember him saying that was a common thing for his condition.
I never said that. I never ever said that
Thank you.
because I didn't know I had a condition. I thought that I was a diabetic.
Thank you. You may step down.
So I know he
Should he
lying.
remain or is he released?
Remain, Your Honor.
All right.
And when he say remain, that's because they think they won.
So what I have in front of me are the following. Motion to suppress the search of defendant's cell phone on the grounds that evidence was illegally obtained. The cell phone was outside the scope of consent. Also, I have before me a motion to dismiss for lack of proper venue, that the charge is based on events alleged to have occurred on May 16th, and that the alleged crime, if it happened, did not happen on the 16th of May. And then finally, that the defendant moves for an order excluding all statements made by the defendant after his arrest on the grounds he did not give a knowing and intelligent waiver.
And
of
that's
his
true,
rights.
but this judge, she denied them all because
Those are the
Gail
issues
Ryder
the court
didn't
has
stand up and
before.
fight for me like a
Any
real
other issues that
lawyer.
the state
She
believes,
didn't.
Remains before the court.
No, Your Honor.
Ms. Ryder, do you wish to put on evidence?
We do not, Your Honor.
Why not? And I had a whole
Clarification
folder.
of the court's
I had a
recitation
whole
of the
folder.
charge before the court.
Thank you.
I believe that the motion to dismiss for lack of proper.
I had a whole folder of evidence at my court date. It was right here. Whole folder. Medical reports. Oregon State Bar.
Thank you, Your Honor. Starting with the search of the cell phone, Your Honor, clearly the officers were there lawfully based on their investigation. They had entered the room, found the defendant's wife, who was clearly prosecuting herself. The defendant was then, he came out of the closet. I guess, as you said, his hands came out first and said, "Hey, I'm here." Brought him out at gunpoint, took him in custody for officer safety concerns.
Voters, man, they lying. I got evidence.
We just heard from Officer Hernandez about that contact, about the search. He verbally read him his Miranda rights. The defendant acknowledged those rights. He did not sign the card because he was handcuffed. The detective informed the court that based on officer safety concerns at that particular juncture, it's very normal for them to keep them handcuffed, and they will write handcuffed on the line of the signature of the defendant, and then the officer signed that. After the Miranda rights were given, then the defendant made several statements, including the consent to his search of his cell phone. In regards to that particular card, as you can see, it says room and car, and I had the officer clarify, that was the first verbal consent that the defendant gave to the search of the entire room and its contents and the car. Here then, when the defendant was allowed to be unhandcuffed because the officer safety concerns were alleviated, then the defendant signed that card saying, "I still consent to all of this," And I asked the detective specifically, was that
They
in relation
lying.
to his
I
cell
never
phone as well?
ever
He
said
yes.
this. I'm telling
Defendant
you
signed
with
that.
all my heart
I think
and in
what
my
also
mind,
goes to
I got all this
corroborate the
evidence
fact that the defendant
showing.
was willing to
And
consent
why
to the
didn't
search
Gil,
was
as
that
my
he
public
gave the
defender,
officer the
put
code,
on my
the only way to get
evidence?
into the phone, which was the
'Cause it's a hate
0550 code, and then the defendant willfully gave that over to the detective to finish searching the cell phone. All the contents that are on the cell phone, of course, at that point would be admissible evidence showing the relevance to the different text messages in regards to Queen Moneymaker, which is his wife, we learned through Detective Smith.
This
The
case is
transactions
going to
that were
make
taking
somebody's
place, the fact that they
career
were-
go
She was getting
over
ready to do a lick. And then, of course, the drug
because of the
records.
slanderous remarks they
So,
made.
I asked the
Convinced
court to
this
deny the
judge
motion
to
suppress
throw
in
out
regards to
all
the search
my
of the cell
evidence.
phone. Moving to the defendant's statement, since we're already talking about the Miranda rights that were read to the defendant,
That
I
were
asked the court
broken.
to say that that was a willful and
No,
voluntary
it was not.
waiver on his part.
No, it was not.
And that he did agree to talk to the officer.
No, I did not.
You heard from Detective Hernandez.
You heard
many
lies.
different quotes, and he specifically
Many
quoted
different
those
lies.
in his report. Statements
His
the
report
defendant
is
was
off.
making,
Roger Smith, the only
in
one that
regards
wrote a
to the actual
report.
contact that he was having. His
Hernandez
role
don't
in
have a
that,
report.
and then saying, "All right, I'm going to be straight with you. I
That's a lie.
portray myself to be a pimp, but it's just something that I've done because of how I grew up and how I lived my life."
That's a lie. I've been
I
in
just do
foster
it because
homes
that's
and
what
in
people
prison.
expect from me. Again, that's an indicator that goes towards the promoting prostitution. His statements about what his role is, the fact that he's hiding in there. The reason I elicited his wife's statements was effect on listeners. She's not here for this motion. Didn't need her to be. It really was the.
Why
effect
didn't
on
you
the
need her?
officers
You
in the
didn't need her in the
investigation
indictment
that showed
process. You
why
didn't need her in the
Detective
motions
Hernandez was
hearing.
asking the defendant
Why
about his
didn't you
comments,
need the
and his
supposed
role in this
victim,
situation.
Douglas
He clarified,
Christopher Hansen?
yes, we do
Why?
this together. I'm there for her protection, etc.
This is all
This is,
lies and slander.
His own statements again, Your Honor. There was nothing in
I never talked to these
did not
cops.
understand the questions, that it was not voluntary. I asked the detective, was he complaining of pain or discomfort or not understanding?
No, he
in any way,
didn't.
shape, or form?
No, he
said
didn't.
No,
No,
The
he
only time
did
was when
not.
At some point, he said, "I'm going to be sick," and he threw up. But again, even after that, there was no talk about, "I really don't understand what you're doing. What's going on here? I'm not voluntarily consenting to any of this." Nothing of that nature occurred, Your Honor. In fact, the detective said that sometimes the defendant was actually laughing at some of his questions. So I think that also shows the voluntariness and the defendant's knowing waiver here. Your Honor, I was not privy to the doctor's testimony.
Look at him,
today. I did speak with
stumbling
Mr.
over his
Keenan,
words in fear.
that portion of the case.
How you know?
My understanding from what the doctor
Each mind is
testified to from the
different.
defense
He
was
could have
that,
asked my doctor something
yes, he
totally
can be
different
certain
than what the
medications,
other
and
man
yes, it
offered.
can cause him some sort of maybe pain or something
No,
like that, but
pain.
nothing about voluntariness of statements or not knowing.
Why
and
everything is
it could
good
be a
on their
diabetic
angle, but
situation,
nothing
again,
is
the defendant
good on
mentioned
mine.
that. He just said, it's
I told
common
him,
from whatever I have here that I get sick.
I
and
never
throw up.
said it's common.
Again, I don't think there was any correlation from what I heard to understand the doctor's testimony.
Ooh,
to be
this man
to
is
the defendant
so-
not voluntarily
Ooh,
waiving his
God.
rights here. So I'd ask the court to deny that motion to suppress his statements. Lastly, on venue, Your Honor, I think the court's
It's a
aware of
law.
new case
I
law
don't care
that came out
what
in
your
regards to
argument
State
is.
Mills, that talked about
Fruit of the poisonous tree says
venue
none of this is legal.
you can't argue venue in the middle of
You
a trial.
can't argue none of
It's not something the
this.
state needs to actually prove venue, but they can raise it pre-trial, and that's what's been done here. As Ms. Ryder indicated, the only issue of venue is to count 2. So let's look at the count 2, Your Honor, which is the delivery of oxycodone. Or Oxycontin. This is an actual constructed delivery.
So
As
why am I
had the
charged
officer
with a
explain,
delivery
well, what
of
are
a
you
controlled
looking at? This is
substance within
substantial
1,000
or
feet of a
attempt
school?
to sell the drugs. That's delivery of a controlled substance by constructive delivery.
But I don't have
The fact
that.
that he had $1,200 in cash.
That
on
was
him,
my money.
Which not only goes to helping prove the prostitution, but it also goes to showing the sale of drugs. He also has the oxy on him. It's not actually on him, excuse me. It was found in his wife's purse, is what I believe the testimony was. But again, it's his prescription. So yes, he lawfully has that, but he's not entitled to then try to sell that. That's what he was
I never
doing in
tried
his
to
phone
sell
messages,
it.
dating back, I think, from March up until the last one, which is the evening of May 15th.
I wish
this
God
to
to
this,
send
this
somebody
person called Nick.
to help me.
And then he's saying,
You know,
I'll sell you
that's
these.
all I
50
want.
pills. Well, weird. It happens to be 50
It's
actual
help.
pills that are still left in the bottle. They're 5 milligram tablets, exactly the same. And on or about, Your Honor, it doesn't have to be a specific date. The court knows that that's not a material element that we have to prove. So in any situation, again, where a defendant may have sent that physical text message at some other location or at a day or two before or a day or two after is irrelevant. The fact is that he's constructively delivering it when he's in possession of the phone. There's indicia of delivery on the cell phone, and he has the drugs with him at the time, and he has cash with him at the time.
So I'm not
the fact that
allowed
he's
to
at that
have
junction
money
within
on me.
1,000 feet of
It's
the school,
against the law for
in
me to
that
have
hotel
money.
room, it's
'Cause I'm a
venue
black
issue.
man.
Really, we have venue when any material element can be proved, and any
Hateful
element it may exist within this county. Well, he's possessing these drugs. He has the.
I can
phone
possess
record
my
with
own
him, or
prescribed
drug transaction
medication.
records,
What
if
do
you
they
want to say
not
that, on his
understand
phone,
about
with
that?
cash and with the drugs.
I never went to
So,
Salem
I'd
with
ask
the
the court to
attempt
deny
to
that
sell
motion.
any
Dismiss
drugs. I went to Salem with the attempt to stop my wife from committing a crime that they eventually charged her for and me.
The only evidence that we have of the attempt to sell the drugs is the May 15th. That would be.
That's what they evidence. That's they evidence that my lawyer's reading off to them, making it seem like it's mine. I got way more evidence than they think.
I would suggest
Way
to the court
more.
that there is insufficient evidence for
Right.
you to lie in Marion County on that case.
And she
without-
still denied it, helping.
Okay. So, it's not always a circumstance that the court hypothetically agrees with, but isn't it the case that if I have a prescription for X and it's filled, and I then give my prescription, my bottle of X to Sam, haven't I delivered a controlled substance? And so in this situation, because it's in his wife's purse, not his possession, her possession, isn't that evidence of delivery within 1,000 feet?
No, it's not. Hell no, Trip. Why
I think
would
you
you
have to know
think
more
that
about
way?
the
As
circumstances of that, because
Right.
that means that every time in Fred Meyer, if I may, that I get a prescription filled and I've got 2 cantaloupes in my arms and I say, here, honey, hold this, and I hand him the prescription, I've delivered a controlled substance to my husband. So I think that's a little bit overbroad.
Okay, fair enough.
Application.
Fair enough.
Okay. In this case, the money that Mr. Johnson has is not evidence of drug delivery.
It's not.
If there wasn't
Because I showed her
attempted
evidence, but she
delivery, which is
excluded
what
it out.
The text
Listen
messages
to her.
are more indicia of. Then we have no idea where that attempted delivery took place.
Don't,
In fact,
because
there's
I was
not an
never in
instructed delivery
Salem.
situation here in Marion County. We've got an attempted delivery, perhaps. But
So
it's
again, why do I get
because
delivery
the
of a controlled
oxycodone
substance
are still
if it was
in
an
Mr.
attempted delivery?
Johnson's constructive possession with them being in his wife's purse, that's what we would argue, and we have no idea where that text was sent.
Right.
With regard to the other
Neither
two
did the
motions,
district attorney.
The motion to suppress regarding his statements and the motion to suppress with regard to the search of the cell phone, those are inextricably tied to his physical condition.
Which
because
I
he
took a
cannot
psych
consent to his
evaluation,
statements voluntarily,
and it shows
and he cannot consent to a search of the
proof.
cell phone
It showed proof how
as well.
ill I
And as
was.
this court heard from Dr. Harbison, the metformin that Mr. Johnson was given did cause him nausea and perhaps some disorientation. Dr. Harbison testified that there were adverse effects to that prescription being given to Mr. Johnson when in fact he was not diabetic, and that prescription could interfere with his ability to cooperate and with his ability to make rational decisions. We would suggest to the court that his vomiting in mid-interview was indicia of exactly the kind of symptoms that Dr. Harbison is talking about, and we would ask the court to suppress both the statements that he made as not voluntary.
And this is
based
true.
on his physical
This is
condition,
true.
And the search of
So I
his cell
can't
phone
give
based
Gail
on his
Ryder
physical
the
condition.
fact that she told the truth, but she didn't want to put on no evidence when I had it all right there to show.
Did you file a brief in this?
And what is a brief? He didn't want to file the brief because he didn't
I
want
understand Ms. Ryder's argument, the defense argument, but when we talk
the
about
courts to know
on or
that my
about,
wife wasn't
so
considered a
the text message from the night
victim.
before is on or about May 16th.
When filing a brief, you need a victim, Douglas Hanson.
What I think the legislature's intent,
Look it.
and the court's intent really is that if you're going to say we don't know where you were physically within this state when you sent that text message, then no county can prosecute the defendant for that. That's why we get to look at then the other indicia of the activity of that drug stuff going on. The night before, he has a cell phone with him at this time. He has stopped. He has cash. He has the drugs with him.
I'm not allowed a cell phone or cash.
I do agree with the court's analysis that.
And then he laughed about it.
Technical delivery when he gives it to his wife, and his wife is the one.
See,
that has
now he's
drugs
going
in her
off of
purse.
what Judge Tripp said.
But when you
Hadn't
look at the
Judge
totality
Tripp
of the
influenced
circumstances,
his
it's a little
mind,
different
what
from
he
when you
would
take
have
a
said?
prescription for a family member and take it home to them. Here, we have no evidence that was testified to by anyone saying why the defendant's drugs were in Miss Johnson's purse.
Why do we
The other
got to
fact is,
testify to it? It's
why is all the cash
why? It's
then
my
not in
wife.
that purse, and why is it on the defendant?
Because it was
So
my
again,
cash
another
from my
indicia of what his
check. She
activity
had
is,
her
both
own
the
money
prostitution and the drug activity.
on the card that y'all
like I said, I
forgot to
think
take.
if you say on or about this date, yeah, we don't have to prove a specific date. I think it's close enough that we have a text message from the night before, and that he's actually there on this
The
date.
text message from the night before says,
I got 50 pills, I'm trying to sell them for $200 to this guy named Nick.
And I got
And
found
then,
guilty.
Of course, then we have the pills
Of
with the defendant.
no
in
contest
the hotel
for that
room,
text
that
message.
corroborate him trying to sell these drugs. It's an attempt. It's
Where's
an absolute
Nick?
constructive delivery.
and the contact with the officer the first time, when the officer basically blew her off and then came back to talk to her again. His testimony was that occurred on what day? Was it the day before?
That was May 15th, yes.
The day before.
The day before.
This is all wrong.
And then he recontacted her May 16th, and they set up that 1 o'clock in the afternoon meeting at the Shiloh Inn.
Wow.
And so
Had
at
nothing
least
to
there
do
was
with me.
evidence
It was evidence.
that she was in Salem.
Yeah, that's it. That she was.
Yes.
The 15th.
Yes.
And she indicated as such in that ad that she had placed.
That she had placed, but they said earlier that it was from my black laptop.
The only other thing
And that I
to
did
say
it.
about the doctor's testimony is
How can he
my
say
understanding is the doctor said
anything
this
about
could
what
have
my
these
doctor
effects,
said?
but he has no idea whether it had these effects on the defendant.
He don't
or he never
either.
heard that it had any effects on the defendant.
He don't either.
He doesn't, of course, have to testify, but there is no evidence before this court right now indicating that he was having trouble communicating because he was suffering from these
Why?
adverse effects that
Okay,
could
there
be
is
there. We
evidence.
just don't
It's
know
my
that, and
mental
that's what
evaluation
was
that Gail Ryder made
about
me
his
take.
demeanor.
Why did she put motion to eliminate to
And
get
again,
that
nobody
eliminated?
thinks so.
'Cause
I'm not
you
knowing
didn't
if
want me to
that
show
was how I feel
truth.
these effects.
You didn't want me to show the correct truth. That's why. I put
I think you've heard my basic thoughts.
this judge wanted to prosecute me just as much as they did.
As to the motion to suppress defendant's statements,
No hope.
the defendant's motion is denied. As to the defendant's motion,
Because I
to
had
suppress
no
evidence,
witnesses.
defendant's
I
motion
had
is
no
denied.
evidence.
And as to the
So
motion
I
to
could kind of
dismiss
stand why the judge dismissed everything because I didn't have proper representation, and that's an ethic violation to Gail M. Ryder.
The court believes that there is evidence that the venue is proper, and so that the motion to dismiss for lack of proper venue is denied.
Wow, I felt
Anything further from
defeated,
state?
but God kept me pushing.
Just that, Your Honor, the state will prepare those proposed orders. I'll submit those to Ms. Ryder for her defendant's review, and then submit those to the
All I
court.
could do is
And I
cry,
think the next
man,
date,
because it was just
that we have
it's just
set, is a
mind-boggling
trial on July
that they
6th.
can do these type of
With
things.
the trial,
July 14th and 15th.
hearing open water. Okay.
They
Ms.
had me
Ryder,
set up.
Anything further from the
No.
defense?
My concern, Your Honor, is that with regard to the motions to suppress the statements and suppress the search of the phone, I think the court needs to articulate a basis for the defense.
So why would you put me on a time frame saying you got until 5 to take this state's offer when you said this, Gail Ryder?
More
Why?
eloquent in writing than I am in off the cuff. I know that some judges believe that off the cuff is great. I'm not the best off the cuff person, so I will write you a probably brief opinion letter that tells you.
I never received that opinion letter because they rushed me into taking the state offer through my email
all of the
address.
motions, if you would like.
Yes.
Thank you. I just think it's required for the record. Thank you very
Well,
much.
where is it at in my
I'll wait for that
information?
opinion letter, that way I can incorporate that within the orders that I present.
That would be fine.
Douglas
All right.
Hanson, you got
So
a
we
lot
will
of
do that.
explaining to do, buddy.
I will tell you that I have been absolutely swamped for
I have
the
a
last few
swamp
days,
judge
and I'm
trying
not sure
to
that will
trial the
give
case
way,
that's very
in the
delicate.
next, last few days.
That's
and in the next few days.
unconstitutional.
But I will tell you that
Pass
it will
my
go to the
case off to
toward
a
the
judge
top
that's
of the
freshly
pile of
that know
things
what
that
the
I
hell they
have
doing.
awaiting me, and I will try to get it to you as soon as possible. We have a free trial on what day?
July 6th, Your Honor?
Next Monday.
Next
I will have
Monday,
it to you on
they
or
was
before July 6th.
giving me
so,
court date after court
You may
date.
get it on the 6th, but I'll try and get it to you on or before then so that the state can get an order and we can move forward from
This
there.
is
All right,
crazy.
we're in recess. I appreciate everybody's time.
Thank you, Your Honor.
Thank you, Your Honor.
This is absolutely the most despicable things that I ever went through in my life. How she showed no hope for me. You know, like I said, I got all this information right here. All that good evidence, and Gail Ryder never once helped me. You know, she just said things to make herself look good as a lawyer, but I can assure you through emails, through teleport, she was a completely different person. Follow me as I uncover more corruption. I got one more video to do, and we'll be up to par on this corruption. It's a hate crime, and I got proof proving it.